Good morning, everyone. Great. You're welcome to Adbond's Real Estate Insight session. And today, for about 15 minutes or less, we have a very interesting topic: understanding tenancy law, tenancy systems in Nigeria. And before we go into the topic, I want us to watch this video for just a few minutes. It's a very short video, so just pay attention.
How to handle wicked landlord.
All right. So I played that video because it's something that most of us are probably used to. We've seen online and we are actually conversant with. You see, when it comes to tenancy in Lagos, in Nigeria, landlords, tenants, dramas, oftentimes there are, misconceptions. There are understandings people have already formed, right, when it comes to that. And in our world today, you fall on either category. You're either a landlord, whether or not you have tenants, you're a landlord, or you're a tenant with a landlord. So that's why this topic is very important. Now let's just take it, from the top. At its core, tenancy law governs the relationship between a landlord and a tenant. You can think of it kind of as the rule book that guides what happens between a landlord and a tenant in a tenancy agreement or arrangement. If we take football, for example, football has a lot of a rule book that guides, what happens on the field, what is considered an offside, what requires a penalty, what to get a yellow card and what to get a red card. So in the same vein, tenancy law governs what happens, every single thing that happens between a landlord and a tenant. What are their rights? What are their duties? What procedures either party must follow in taking the tenancy or in vacating the premises. And the tenancy law protects both parties. So the purpose for a tenancy law is to protect both parties in the agreement, like I stated, by governing almost everything that happens between them. So any and everything that you can think of within a tenancy agreement, the tenancy law has provisions for them. We have rent payment, maintenance, privacy, notices, repairs, literally everything, right? As we go ahead, we would dissect each and every one of this and give proper explanations to them. Also, it's important to note that tenancy law starts from the moment a tenancy starts. So certain times people will assume that until they move into the apartment, like they move all of their loads in, or until the tenancy has started counting, the period has started counting, that's when tenancy law takes effect. No, from the moment a tenancy starts, tenancy law takes effect. So let's establish some ground rules, because there are sometimes some common misconceptions people have or misunderstandings when it comes to tenancy. Tenants, landlord, pay attention. Tenancy starts before signing a written agreement. What does that mean? Tenancy starts so long as rent has been paid. You've paid rent to the landlord. Let me give an instance. Probably, you know the way property viewing or inspection happens in Lagos. They take 10 of you to go and view one property so that everybody is in a hurry to pay. So when you get there, you see what you like. Immediately you make payment. You tell your agent, I've paid, though, I'm the one taking it. You've paid. Your tenancy has started. Maybe not the tenancy period, but the relationship between you and the landlord, something has started by exchange of that money, by paying that money. Also, when possession is given. Now, possession in this sense does not mean the date you move in. It means that you've gotten the keys to the apartment. You've gotten the keys to the commercial property, whatever it is. The fact that you've gotten the keys, your tenancy has started. So from that moment onward, tenancy law is governing whatever happens between you. Also, oral agreements are legally enforceable, although proving its terms are more difficult. We've experienced this sometime or the other, but we just don't know it. For example, you move into a property and your landlord tells you, or you notice there's debt on the prepaid meter, and your landlord tells you, oh, don't worry, just deduct it from subsequent rent, maybe 2 years, 1 year, as it were. And then from the next payment you're giving me, say there's 100,000 debt, and it says deduct 2-time payment, that's 50,000 this year, 50,000 next year. So the tenancy has started, right? The tenancy period has started. Your tenancy expires in August. August comes, you deduct 50,000 from 500,000 and you send 450,000 to your landlord, and then the argument starts. When did I ask you to deduct it? You would have told me, I would have paid. You start back and forth. But you're the one that told me to deduct it from. There's no written agreement anywhere, no evidence. If your landlord cannot read and write it on their behalf. Let them thumbprint. We have phones these days. Make a video as you're writing it as is thumbprinting. Several things can help to serve as evidence in the court of law, but word of mouth can always change. In court, they call this hearsay. Somebody said, he said, she said. There's no evidence. So a signed binding written agreement provides a stronger evidence of what you actually agreed to. It's easy to say. They will ask you in whatever dialect, Baba, are you the one that signed this? He says yes. Madam, are you the one that signed this? Yes. And so it's binding. Then Nigeria does not have one single tenancy law that applies everywhere. Absurd, we know. But take for instance Lagos. Lagos has Lagos State Tenancy Law that guides whatever happens when it comes to tenancy in Lagos. When you get to Abuja, there's the Federal Derived Act. In Oyo, there's the Recovery of Premises Law. So we don't have one single law that binds tenancy in the whole of Nigeria. So take note, if for example you move from Lagos to Abuja, the laws, principles as regards some of those things we mentioned here could change depending on the state you are within Nigeria. So we've established this. Now let's look at the types of tenancies that we have. Yearly tenancy, we're very conversant with this. Every year you pay your rent to the landlord, and it often applies to residential, properties. Next, we have monthly tenancy. Rent is also paid every month, and it's very common with shops, with smaller apartments. Let me also state here that monthly tenancy is gradually becoming a thing in certain parts of Lagos State, where fully furnished apartments, you move in and you pay your rent on a monthly basis. This doesn't mean you might stay for up to a year, you might stay for 12 months. It's not the business of the landlord. Every month you have to pay your rent. Then there's weekly tenancy. Applies to temporary accommodations like hotels, hostels. You might not see it as some sort of tenancy. After I'm just staying for 5 days, but in real estate is considered a type of tenancy, a weekly tenancy. Now we have fixed term tenancy. For fixed term, it runs for a specific duration. That means when you are renting, it's stated in the agreement that you're renting from 1st of December 2026 till 1st of December 2028 is defined, and you are paying your 2 years rent for that period. It often applies to long leases. People that are leasing commercial property, you can lease it for 15 years, 20 years, what have you, but it's defined. The period for which the tenancy would run is defined, and oftentimes it will need a renewal after the expiration of that period. So that's a fixed term tenancy. Now we have tenancy at will, where the tenant stays with the landlord's permission without a fixed period. Let's give an example. Mr. Timothy is transferred to the Abuja branch or the Abuja Experience Center of Adbond Harvest and Homes. He moves with his family and tells a church member, you can stay in my apartment. After all, we're not there, so you can stay here for a period. It doesn't state the period, but you can stay here for a while. When I need the apartment, I would let you know, right? There's no defined period. The person just says, you can stay in my apartment for after I'm not here. And if you look at it, most of the residences people have before they eventually get settled in life or they eventually establish their service, almost similar to a tenancy at will. It sometimes applies to family members. You started staying there. You said, oh, I'm working at Ikeja, for example, so I'll stay here on weekdays. Weekend, I'll go back to my place. And then the first weekend, you go back. Second weekend, third weekend, you don't go back. Fourth weekend, you don't go back. If they ask you years later, how did you even start living there in the first place? You don't even remember. So oftentimes, it's tenancy at will until the person says, oh, I'm getting married, I have to settle down. You have to look for your own place. And again, it's often applied to guys where a lot of you just end up staying in an apartment. Even the original owner might not be known. Now, tenancy at sufferance, the tenant is no longer lawfully entitled to remain, but cannot be thrown out without following legal procedures. For this example, the tenant is now a tenant in Sonu. The landlord has said, vacate my property. Maybe there is even a legal justification for which he has to chase you or send you out of his property, but you've refused to vacate. That's an example of tenancy at sufferance. And so in most cases, oftentimes, the landlord will want to resort to unlawful procedures or illegal procedures. But for tenancy at sufferance, the tenant should no longer be there. By law, lawfully, he has refused to vacate the premises. So we've established we have yearly tenancy, monthly tenancy, weekly tenancy, fixed term, tenancy at will, and tenancy at sufferance. Okay, so now let's look at some of the rights of landlords and tenants when it comes to Tenancy. The landlord has a right to receive rent as at the time stated and of the agreed amount stated in the tenancy agreement. So it's his right, he's the owner of the property, to receive rent. And in an instance where the tenant defaults, then he can follow legal procedures to recover premises, to recover his own apartment. Then he has a right to inspect the property. Yes, the landlord can conduct inspections on the property at intervals, of course with adequate notice to the tenant, meaning I want to come and see if my property is being maintained, if my property is used for the purpose for which the tenant says he wants to use it, but he has to give adequate notice to the tenant for various reasons, to respect the tenant's privacy and also to ensure that somebody is home that can, be with you and your agent while you are doing all of the, checks. So yes, he can inspect the property but with adequate notice. It's also important to note here that there are some instances where adequate notice might not be a necessity. For example, in the case of an emergency, there are videos that trended online for a while about POPs falling out. In that case, your landlord wants to come and see you, say you do not send me notice, you cannot enter. You and the POP will be there. When you're ready for him to enter with his artisan or repairman, then it will get repaired. Then to recover possession through lawful procedures, we already stated that it's his property. He has a right to say, okay, following legal procedures, I would want you to vacate after so and so period. Then he has a right to enforce the tenancy agreement to ensure that no, the landlord has a right to expect that the tenant will comply with what is stated in the tenancy agreement. If the tenancy agreement states you are using it for a residential purpose, don't start a small business, a small online business. It could be in breach of your tenancy agreement if it's not clearly stated there that you can start buying and selling within the premises. If the tenancy agreement says you cannot sublet, do not sublet. What is a sublet? You're the one that rented from your landlord. Let's say you rented it for 600,000 naira or 400,000 naira annually. You then rent it out to somebody else for 600,000 annually. You are not even the one staying in that apartment. Certain times landlords frown at such and they will state it in their tenancy agreement. You cannot sublet. If it states that, do not sublet. Now, he has the right to seek compensation for damage caused by tenants. When a tenant uses a property, it's normal for there to be wear and tear. Maybe the paint is not as sharp as it used to be. That's normal. But like the video we played earlier, you intentionally cause damage, unnecessary damage, avoidable damage to the property of your landlord. Yes, your landlord can sue and get compensation for it. So it's important to know that as a tenant, carrying out avoidable damage, something that is avoidable on the property of your landlord, you would have to pay compensation for that. Now, as a tenant, you have a right to peaceful enjoyment of the property. The tenant has a right to use the property without unnecessary intrusion or disturbance by the landlord or the agent or somebody related to the landlord. For example, in an instance where your landlord is not even the one living in that compound or that apartment, we had those scenarios where it's the landlord's younger brother or the landlord's second generation cousin living in the compound, and then he serves as the human CCTV telling the landlord every single thing that goes on in the property. You can't have a breathing space. Something goes on, it calls the landlord. Another thing goes on, even things that are not necessary, it's calling the landlord. As a tenant, you have a right to say, I have a right to peaceful enjoyment of my property, and then you can take it up. Then you have a right to privacy. A tenant has a right to privacy of the property he has rented and paid for. In the privacy also relates to giving notices where necessary. Aside from giving notices, as tenant, you have to give your consent. So the landlord can send you a notice for so day and you tell him, I'm not available so day. The landlord should not come until you've given consent that he can come on that day. Now, protection from unlawful eviction. What do we mean by unlawful eviction? Removing the doors, disconnecting electricity, changing the locks in somebody else's apartment, changing the locks, sending thugs. Those are examples of unlawful eviction. Weird and insane things happen within the real estate space or tenancy in Nigeria. How can you go to somebody's apartment and you change the padlock that is there? You break the one that is there, put a new one, or you even change the locks, the key to the property itself. As a tenant, the law protects you from that. Your landlord doesn't have a right to do that. Whatever the case, you have to take it through lawful or legal procedures. Now, proper notice before termination. Notices depend on the state that you are in. For example, in Lagos, if you are a yearly tenant, it states that you should be given at least 6 months, right, before your 6 month notice before your landlord requires you vacate the property. If you're a monthly tenant, if you're a quarterly tenant, depending on your tenancy period, there are notices that should be given. So the law allows for that, that before you vacate a tenant, before you terminate it, there are legal ways to terminate tenancy. Then reasonable use of the property. The tenant has a right to use the property within the terms and conditions stated in the agreement. The landlord cannot start coming up with weird terms and conditions after the tenancy has started. There are very good examples in Lagos, for instance. We have instances where the landlord can say you cannot fetch water within the compound anything past 7 p.m. Some landlords will tell you you cannot have visitors over on weekends. Some landlords will tell you, as a female tenant, you must never have a male visitor. So there are instances like that where what is stated is not part of what is in tenancy agreement. It's just the person's personal opinion flowing, to the tenancy agreement he has. It's not stated in the agreement. Now, what are examples of reasonable restrictions a landlord can put? Don't use my property for illegal use is reasonable. You can't use it for illegal use. Another reasonable one is say don't cause damage to my property. That's a reasonable restriction a landlord can put. Even to some extent, some landlords can reasonably say they don't want pets within their premises. It's reasonable, so long as it's been stated before. You cannot put pets in this apartment. Imagine you have an apartment of 4 floors, of you want to put pet. If everybody has dogs, how is it going to look like? Better yet, let's just get one uniform security, for the entire premises. So that's an example of a reasonable restriction. Now we have duties of the landlord and tenants. For tenants, it's your duty to pay rent when due. You cannot say you want to punish your landlord, and so because of that you will decide that instead of paying rent in January, you will pay it in February to punish your landlord. Let me break it down. If you decide to do that and your tenancy has expired, then the landlord does not need to give you a 6-month notice to quit. It just gives you a 7 days owner's intention to recover premises, and that's it. You have to move out because your tenancy has expired. You've not communicated the reason for the lag in payment. You've not said anything. You just decided, I'm not going to pay him. But that thing he did last year, you'll be suffering this year. No problem. If your landlord knows the law within his right, he just sends you a 7 days owner's intention to recover premises, and you have to vacate the premises. So punishing your landlord by withholding the rent is not a legal thing to do. Or to say, what has he been doing since I rented this property? Is it now when you're supposed to pay your rent? Pay your rent when due. Keep the property reasonably clean. You don't want to live in a jungle. You're the one that rented the property. The least you could do is sweep it, maintain it, keep it clean. Nobody is asking you to repaint every year, but keeping the surroundings clean, ensuring there are no grasses growing and all of that. Then avoid illegal activities on the premises. Let's explain that. There are instances where people will carry out. There was a property that when I was in IT then in Ikoyi, they carried out illegal activity on the. It was a full-blown Yahoo spot, right? And then they were arrested. They took over. Do you know that for nearly 6 months we couldn't have access to that premises? And the law agents were within their rights because they said they were still investigating, checking out a lot of stuff. It became the problem of the landlord. Mind you, the stigma followed the property for months. Nobody wanted to be associated with a property that had been used for illegal purposes. So it's important to note that you avoid illegal activities on the premises. Then avoid causing unnecessary damage. We've stated it. I did POP. He then gave me a 6-month notice to quit. He's joking. I will remove everything. I will leave property the exact way I met it. You're damaging it. Some upgrades you do to a property, some upgrades you do to an apartment are fixed. You cannot start removing it without damaging it. I'll give a very good example. Where we have our office, when I come in sometimes and I see the upgrade Adbond has done, I will ask, this thing, we cannot remove it when we are leaving. And they say, no problem, we don't intend to remove, because imagine you're removing this type of door. What do you want to put back? Nets? So you have to note, do your maths as a tenant. If you know you want to upgrade the space you are living in, do your maths. Ensure that it's something that, okay, if you're living, you can leave behind. Don't get angry and then start destroying things within the property. Then notify the landlord of serious defects. Things like major structural defects, major structural damages, maybe there's a pipe leak within the wall, major electrical issues. It's important you notify your landlord. Then you comply with the tenancy agreement. We've stated this. Your tenancy agreement states you cannot bring pets, don't bring pets. Your tenancy agreement states you cannot use the property for commercial purposes, don't use it. It says You cannot sublet, do not sublet, follow your tenancy agreement. Then for the landlord, you've established all of this to provide possession of the property. They've paid, they should have possession. To respect the tenant's privacy. We understand that it is yours, but for the moment you've paid rent, then the tenant has right to, for the moment the tenant has paid rent, they have right to privacy. Then carry out the repairs they are responsible for. There are different categories of repairs within a property. You have to determine from the tenancy agreement, determine what am I responsible for, what is the landlord responsible for, clearly defined. Then to honor the tenancy agreement and avoid harassing the tenant. Now let's look at a sample. This is not a sample, it's just an outline of what is needed for tenancy agreement. If you want tenancy agreement, like go to ChatGPT, go and download. Don't get a proper tenancy agreement from a lawyer. You would find out why that is not good. Anyway, for tenancy agreements, for example, you have to state clearly the address of the property. Where is the property located? It's very important. Then the term commences on for a fixed tenancy and expires on. If it's not a fixed tenancy, just state the start so period, renewable every year. That's simple, right? Then you have to state the rent amount. How much this person paying for rent? Then rent increases. From tenancy agreement, you know, if your landlord states rent will increase every year, you can quickly debunk that. Nope. We can work with 3 years. Instead, I'll pay this amount. Then your security deposit, which we call caution fee. Some persons, when they are leaving, they don't even remember to ask about it. If you maintain the property as at when you, which most times there's no way to look like the way it was when you rented it. But then if it is refundable, truly have conversations about that and state it in the agreement. Service charge where applicable. There are certain other charges that come with renting a property. There's electricity, there's water, there's waste, there's service charge. All of that has to be clearly stated. Then yes, their payment date, is it paid first of every month, third week of every month, last week of every month, like that. Then maintenance responsibility. Repairs should be clearly allocated to avoid disputes. Structural and major damages. Okay, landlord, you're going to take anything major. For example, the roof removed, who's taking charge of that? There is, maybe God forbid something happens and then there's a crack in the wall, who's taking charge of that? If the pumping machine spoils, who's taking charge of that? Now, little things like maybe the water faucet has issues, your flusher is not working clearly, who is taking charge of that? It has to be clearly defined. Some people will say, what is he using the rent we are paying him to do? How is that your business? Come to terms with agreement on maintenance responsibility. Otherwise, you'll be there for a long period and you wouldn't have a fully functioning apartment. Damages caused by tenants will have to be clearly defined. In an instance where you are trying to carry out alterations that you did not get approval for, and then something happens. I had someone that was trying to move the wall. She believed that the way the wall was placed in the living room was wrong. So she said the living room was not proportionate to her kitchen. So she wanted to rearrange it as a structural engineer that she was in her mind. And then she started the project. By the time she understood the impact it was going to have, it was leading to, hundreds of thousands that she would have to spend. And the landlord said it's none of his business. First, you did not get approval for the alterations you're carrying out. Then second, it's a major structural. Who are you to say I do not know how I built my house, right? And then it became a major issue she had to pay hundreds of thousands for. So ensure that before you do certain things, is it in my agreement? Then is it something we need to have a conversation about? And then there's evidence of the conversation. Then other important information, duration of the tenancy, permitted use of the property, dispute resolution. How do we resolve our dispute? Renewal times. Am I the one to initiate renewal? Is it the landlord? Or do we both have to initiate renewal within maybe the last 6 months? Somebody has to reach out to say, I want to renew, I don't want to renew. Then the details of the parties. Very, very important. What's the name of the landlord? What's the name of the tenant? If you have witnesses to state it. Signatures of the party and how you want to end the tenancy. We're stating end the tenancy here because even though the law gives it gives the duration that needs to be followed for a yearly tenant, it also states that it's subject to the tenancy agreement. So if your tenancy agreement states, I will tell you 3 months to the end of the tenancy, note that and prepare yourself accordingly. Then how to end a tenancy. Lagos landlords, Nigeria landlords, leave my house next month. That's not a process for eviction. Telling your tenant, I want to use the property, my younger sister is coming from abroad, I want to use property, leave my house. That's not a process for eviction. The first thing, you have to serve a notice to quit. When you serve the notice to quit, we've agreed for an annual tenant, you serve a 6 months notice to quit. Generally, the notice depends on the type of tenancy. Then after that 6 months, you've served it, the person has not moved out, then you can serve a notice of owner's intention to recover premises. This is served after the notice to quit expires as a further statutory notice. Then for the court process for lawful eviction, the court will check. You can't just go to court and say, I have a tenant, I've told him to leave my property, he has not left. Where's your notice to quit? That's why you need to do it by, like I stated there, a qualified proper Nigerian lawyer. So you just say, I've served him notice to quit. The notice to quit does not even have heading. You just say, leave my property, I want to use it, so and so, and you serve it to the person. If they ask you, okay, where is the evidence that your tenant received the notice to quit? Where is the copy that shows that he actually received it, so you served it properly, right? Then tenancy must have expired as well before you can begin that. Then by all means, avoid self-help eviction, throwing the belongings outside, cutting off utilities. Avoid all of that as a landlord. Receiving rent after serving notice to quit or expiration of tenancy. The belief is that if you receive rent, in some cases it is seen that you intend to actually continue the tenancy. So if you've served notice to quit, you've told the person 6 months, then the person reaches out and pays and you collect the rent again, obviously it's null and void. You don't need the notice to quit again. Then verbal agreements, avoid verbal agreements, document all decisions, have it prepared or reviewed by a qualified Nigerian lawyer. Ensure that everything that is agreed upon is clearly stated. There are instances where, let me use the prepaid meter example again. When you moved into an apartment, there was no prepaid meter. You then decide to use your money to acquire it. The landlord then says, oh, I will give you the money back. The next rent he doesn't give you. When you're not leaving, you remove it. Okay. Next, there are big lessons when it comes to tenancy. At its core, the laws and legal principles governing tenancy seek to balance the rights of the property owners with the rights of lawful occupants, the person that owns the property versus the person renting it. Let's look for a balance so no party feels cheated. Then the most successful landlord-tenant relationship are not built only on trust. They are built on clear agreements, good communication, proper documentation, and respect for legal procedures. Clear agreement, it's clearly stated. You clearly have the understanding of it. We're emphasizing on this because most people are in a hurry to move in. You move in, you don't have a tenancy agreement. Sometimes 1 year, 2 years, 4 years, you've been in the property, no tenancy agreement. You say the baba is a good man. He's a total good man. He doesn't, I can trust that baba. The day the baba will wake up and say, I need this property, then you will understand. Then understanding these principles helps prevent disputes, protect investment, furthers a more professional and real estate sector. Understanding that tenancy in Nigeria is governed. There is a law binding it. There are, principles to follow, legal procedures to follow. So if you have any questions, comments, inquiries, first you can make use of the comment section or you can reach out to us via any of these means. Thank you very much for your attention.